Okay, I think it's time. Welcome everybody, and also welcome online. My name is Diana Pfau, and today we're going to make a short introduction to the legal aspects of federated learning and overall machine learning. Now that we have both in person and online, could I ask everybody online and in person, did you ever have an introduction to data protection law before or any kind of legal lectures? No? Okay, online, anybody? Okay, it seems like not. Okay, perfect. So this is really meant as an introduction. It's not required that you know anything beforehand. And the way that we're gonna go forward today is first, I'd like to introduce what you're supposed to know after this lecture. So I'm trying to provide you an intuition about the GDPR and the AI Act, which are the applicable legal frameworks. And hopefully after this lecture, you would know when would you have to check if the GDPR or the AI Act apply and based on which requirements do they apply. I also hope that you can list the requirements for when the right to explanation that I'm going to introduce afterwards applies under the GDPR, and that you could determine whether an AI system falls under the definition of a high-risk AI system. So we're first going to go through the primary question, I guess, for everybody. Why do we need privacy, and how is privacy even connected to federated learning? Afterwards, I'm going to give you a very short introduction into digital regulation within the EU, the GDPR, the AI Act, and then we'll have a very short discussion about social media platforms. So the way you have been introduced to federated learning is obviously much more varied, and you have seen a lot of technical implementations. When I think of federated learning, I'm imagining very basically a system like that. You have clients. These clients share gradients with a central server, and you get back model updates. So this is enough for this lecture. There's not going to be anything more technical. Federated learning was first introduced by Google in 2017. And it was advertised in a research paper as privacy friendly. As we're going to see, that does not mean that the GDPR does not apply. It does not mean that digital regulation does not have problems with federated learning. So local models still utilize personal data, for example, in healthcare, if you want to share different rare disease factors with between different hospitals. You would still be using personal data or special categories of data. Gradients can even still be personal data in the way that you can reconstruct the initial data. And as soon as this happens, you might have personal data. And even model updates can deliver the same. So first question, why is privacy important? Privacy is oftentimes named as an enabling right, so it safeguards other rights. Freedom of thought, freedom of speech, in a sense that unless you have the right to be left alone by others and you have your private sphere, you might not feel comfortable to share your opinions. You might not feel comfortable to expose yourself. Then it also safeguards individual autonomy in the sense that nobody is allowed to interfere into this private space. So you have the right to make decisions about your own life freely. It also safeguards from discrimination in the sense that certain attributes might be vulnerable to discrimination, and you don't have to disclose them if you don't wish to do so. It also protects from fraud and identity theft. And the way that I like to think about privacy in a very basic manner is the right to be left alone. So you have your private sphere, and you have a right that nobody else intervenes into the sphere. In the EU now, we have different ways of implementing privacy. We first have fundamental rights-based regulations. So privacy is a fundamental right in the EU. Data protection is a fundamental right in the EU, and data protection just means you have a right for your personal data to be protected. In the EU, we have the GDPR, General Data Protection Regulation, that attaches to personal data. We have the e-privacy directive that attaches to communications. And we have the law enforcement directive that attaches to personal data, but in cases of criminal law. So for witnesses, suspects, defendants, these people are like, then you apply the LED. On the other hand, there is a lot of discussion about the power of different providers, may it be AI providers or other service providers and tools. And in order to curb their influence, to ensure that the internal market works fairly, there are no monopolies, and you are protected, for example, from illegal content on social media platforms, you have digital governance regulation. They're internal market based, and they don't attach to personal data, so to your personal rights, but they are meant to balance the internal market. For that, we have the Digital Markets Act, which deals with very big online platforms. The Digital Service Act, which deals especially with illegal content. The AI Act attaches to AI systems, and the Data Act. So what we're first going to look at is the GDPR. As I already said, the GDPR applies to the processing of personal data. That is the attachment point. And it lays down the rights of the persons whose data you're processing and principles of the processing of data, together with responsibilities of those who process your data. Personal data, as I've mentioned the name so many times before, is any information that relates to an identified or identifiable person. That also means that completely anonymous data would not be considered as personal data. However, the anonymity standard would be that there is no reasonable means to expect that anybody would be able to re-identify the persons whose data you have anonymized. So this might not be always the way to go. It's a little bit dangerous in the sense that who can guarantee anonymity for the whole life cycle of personal data? To determine if a person is actually identifiable, it's sensible to take account of means reasonably likely to be used. So if it is extremely unlikely that I can single out a person, and here I have to say singling out could be, we are all here, there's one person in a red sweater with glasses. Already this identification, together with other information, can constitute personal data. So singling out is a concept that you should always take into account. So, as I already said, it is not necessary that you have specific identifiers. I don't need to know your name, for example, in order to have personal data about you. It is enough that out of a crowd, I can single out a person based on specific characteristics, their behavior. So based on that, and I'm asking the audience in the room because I'm not so sure if the people in the audience can actually even unmute themselves, is the name a personal data point?
Yes.
Perfect. Is a health record detailing maybe not only my name, but let's say a health record that contains data about my blood pressure, my age, weight, height. Would that be personal data? Perfect. A company email address that has my name, last name, and then the name of the company. Would that be personal data? It would be. In fact, this is a very interesting point. If a company email address has your first and last name, it's still considered personal data. Would it be something like privacy@company.com? It's not personal data. But as you have a prohibition on direct marketing for personal data, you should expect that whenever you get an email to your company email that says first name, last name, this is probably unsolicited marketing and therefore should not happen. Is an IP address personal data?
I guess maybe not, because it changes. Actually, it's not applied to you, but I don't know, that's I guess.
In fact, it is considered personal data under the GDPR.
So, I know somebody gets access to my previous IP address, I guess then they would know who I am. So I don't know, that feels a bit weird. IP addresses are like shared.
Yes, but it also depends. Can I single you out based on your IP address? It doesn't have to be that I can single you out for your entire lifespan. So I can identify somebody based on an IP address plus other information, right? So that constitutes personal data.
Yeah.
Exactly. Then what about a grade or written note about a student's performance?
Is the name included?
Let's say the name is not included, but what is included is this is the grade. The student has performed fantastically, has had many questions, has asked this and this, has provided this and this assignment, and I have given this and this grade. Can this constitute personal data?
Yes.
Yes, perfect. Okay. I know it's not a very clear definition in the sense that it's very wide and it's context dependent. But whenever you are confronted with this question, just ask, is it possible to single out the person? So as soon as you can do that, or you attach additional characteristics to a name or to an identifier, it's pretty safe that you're in the realm of personal data. Okay, so let's jump shortly to how the GDPR actually looks like. So I'm not expecting you to read it. It's very long. It's probably not very interesting to you, but what is important is that the GDPR applies to processing of personal data within the EU. So that means when you are in the EU, but also when the entity that is processing information about you is in the EU. Article 4 gives the definitions of the terms that are used. So, for example, you will find personal data there, profiling, and so forth. Importantly, in Article 5, we have the absolute standard for the GDPR. Those are the principles of processing. I'm going to introduce them a little bit later. But I really want you to take away from today that the principles of processing, as soon as you have personal data, are mandatory. All processing operations should adhere to the principles of processing. Then you have the legal basis of processing, which means that you cannot just choose any kind of processing and do it. You need to have a legal basis. We're going to talk about this a little bit later, but that is a precondition for the processing. Then this is relevant for everybody, no matter if you're going to work in the field or not. Everybody whose personal data is processed has rights. These rights require you to be active. So let's assume you go on a website, you read a privacy policy, and you consent. Afterwards, you think, hey, actually, what was in the privacy policy, they said they're going to ship off my personal data to a country I'm not okay with. I have more questions. Then you will want to have a look at your rights. You firstly have the rights to be informed about the processing. So any kind of processing that takes place, which means collection, storage, deletion, this has to be, the information about this has to be given. And it has to be given to you in some form or manner, usually in a privacy policy, sometimes in a contract, depending on what the service is. You always have the right to get access to your personal information. You always have the right to rectify your personal information. So, for example, if you have a name change or you realize in some service your age is wrong, you can always send them an email and ask to rectify your information. You also have the right to erasure, also called the right to be forgotten. This is one of my favorite rights, and I think it's very important that we know about it. It's based on a case called Google Spain. And what happened was that there was a man who went bankrupt. There was an article about it in the Spanish newspaper. And many years later, when he searched his name on Google, he could still find this bankruptcy filing in the newspaper. So that was one of the first results that Google gave to his name. So he went to court and he said, hey, this does not reflect me anymore. I don't want Google to show people as a first thing that 20 years ago I went bankrupt. And he won the case. So the basis of the right to be forgotten is literally that if something doesn't reflect you anymore, if you want something to be gone, you have the right to ask for that. Obviously, there are restrictions to that, but generally, as soon as something does not reflect you anymore, you have a right to ask for erasure. Then you have a right to restriction of processing. You have a right to data portability. That just means that if you want to change providers, service providers, they have to give you all your personal data in a readable format so that you can basically take this data, ship it to somebody else and say, hey, I'm your customer now. You have the right to object to processing, and you have then Article 22, which is the only article that actually deals with automated decision-making or machine learning in the GDPR. Otherwise, the GDPR is completely technology neutral, so you will not find any methods or approaches. After that, we have different definitions for controllers and processors. So controller is the entity that defines why and how your data is going to be processed. Processor are entities that help the controller in the processing of your information. Now let's talk about the principles of processing. So as I said, the principles always apply to all processing of personal information. The first principle is actually threefold. The first one is lawfulness. Lawfulness means that you always need to have a lawful basis for processing. So you need to have a legal basis. Then fairness, also a very interesting principle, means that you're not only not allowed to discriminate against certain people, but you're also not allowed to manipulate people. And that does not only include the initial data collection, that also includes, most and foremost, the design of a tool. If I manipulate or nudge people into accepting privacy policies that are not favorable or terms that are not favorable, like for example, when you look into privacy policies, have you noticed that it's always I consent in bold, and then somewhere in very little text it says I do not consent or I reject these cookies? Has anybody seen that before? Yes? Perfect. That is an example of what would be unfair, because the option that is more privacy preserving for you is hidden. And that is what we're trying to prevent with the principle of fairness. Another one is transparency, which means that the whole process of the processing of the personal data itself should be transparent to the person whose data you're processing. This is also why we have the information rights. Then we have purpose limitation, which means that you are not allowed to just randomly collect data and hope that you find something interesting, but you need to define the purpose for which you're trying to collect data beforehand. You also need to communicate it beforehand, so it makes sense that this has to be done before you collect any information. And this purpose has to be specific. You can't say, I'm hoping to find something, but you can say, I need to collect certain health data because I'm trying to predict AB. This would be a purpose that would be limited in scope. Then we have data minimization. Data minimization is oftentimes said to be in contrast to how we use machine learning. And data minimization basically just means you're not allowed to collect any data apart that data that is adequate, relevant, and necessary for the purpose that you have defined beforehand. So you're not supposed to just collect as much data as possible. It has to be absolutely necessary data. Storage limitation, also an interesting one in the course of machine learning, means that as soon as the purpose for which you have collected the information is reached, you can no longer store this information. So you have to delete the information at some point. This can be given by law sometimes. In the course of AML, you would have retention periods that are mandatory, or in the course of financials, it could be 7 years. But after that, you have to delete the information, and you have to be able to delete this information. In a technical, practical context, this also needs to be taken into account before you start processing. How am I going to be able to delete this information later? Then we have accuracy, that also refers to the right to rectify your information. And we have integrity and confidentiality. And this principle focuses on the security of data. So data protection obviously seeks to protect personal data of the individual. And while it is not the cybersecurity regulation, one of the principles is that you have to make sure that wherever you keep your data, you keep it safe, you have an access control. Only those who need to know will know and have access to a system. And overall, you try to establish as many safeguards as possible, depending on how sensitive the information is, to keep it safe and to ensure that no third parties can actually access this information. This one is super important. And I think I was a little bit fast. Do you have any questions about these principles? Yes.
So assume that I'm doing experiments and sort of experiments with human subjects. And for the moment, I want to collect some data. Can I say, for example, well, I'm collecting more data than I need, but I might need it in the future because like these experiments are so expensive, and like, can it be like a future use justification? Because collecting, for example, healthcare data is very expensive,
Yes.
and you don't have a lot of chances to do experiments or collect this patient data like a lot of times. So as a researcher, you have incentive to collect as much data as possible, even if you're not using it at the moment.
Yes. So there are two ways to answer this. The first one is you cannot collect information based on I might need it in the future. That doesn't work. But, and here comes the second one, you are a researcher. There is a scientific exemption in the GDPR. So with this scientific exemption, you don't have to apply everything in the GDPR. It's meant to allow for researchers to collect information. So the route you would go down here would be slightly different. In a case where you can make a good case for, I might need this in the future, I'm a researcher, you could try to argue that, but even then, this is something that would go through the university. They would guide you on what is acceptable. I'm not really a professional in the scientific exemption, but generally outside of research, no. Yes.
I assume you've been talking about like individual data.
Yes.
How does data privacy of companies compare to like individual? For example, let's say Google gathers data from another company. What rights does the company have to like information from their
Could you elaborate which type of data you would be referring?
Just like in general, like this individuals data rights compared to companies.
So when it comes to company versus company, that does not fall under the GDPR because GDPR deals on personal information only. So in these cases, you would usually go via contracts. Yeah. Any other questions? Oh, yeah. Okay, so the question is regarding personal data examples. We discussed that IP address falls under the realm of personal data. What can be considered personal data depends. Does what can be personal data considered personal data depend on the purpose we are considering studying the data for? Yes, it is context dependent in a sense that depending on the context, things that might be personal data can be personal data or not. That is a little bit confusing. You always have identifiers, they will always be personal data. However, depending on the context, you have to make an assessment because the definition is so wide. So the short answer is yes. Okay, I think Yeah, for those who are online, please just drop messages in the chat, or I think you can unmute yourself. We've heard that earlier, I think. Okay, then let's move on. I've shortly said that we always need a legal basis for processing, which comes from the idea of lawfulness. There are many different ways of processing, but in a normal commercial context, what you mostly will see is consent. And consent is very interesting in the sense that it requires a freely given indication of your will that is based on information given to you. So consent is interesting in the sense that you could, for example, not use this when you have big power imbalances. So in employment, oftentimes consent cannot be used because of that, because you need to have the information and you need to have the option to not consent. Consent is not valid when it's coerced. Then you have the necessity for the performance of a contract. So when it is absolutely necessary for the performance of your contract to process certain information, then this is a legal basis based on which you can collect information. It can also be necessary for compliance with legal obligations. So if you have, as an employer, for example, you might have requirements to report certain information about health to the authorities. That would be an applicable legal basis for processing. Okay, I hope you forgive me for the jumps. So we have discussed personal data as any information that relates to an identified or identifiable person. And now we have an additional layer on top of this, and that is special categories of data. So the main difference is that this is very sensitive information, and it's basically personal data, but that reveals information about your racial or ethnic background, your sexual orientation, political opinions, trade union membership, or biometric data. Also, because we are often talking about federated learning in health data is special categories of data. This data is technically, firstly, prohibited to be processed. So the way the GDPR works here is that these special categories of data are ruled upon in Article 9. The first paragraph says, generally it's prohibited. And then the second paragraph says, okay, but there's a lot of exceptions to that. And one of those exceptions that I think is very important to mention is explicit consent. So I've told you that consent is a freely given will, indication of your wishes. It's an affirmative action, so just having a pre-ticked box is not enough. It's based on the information that you're given, so you need to have a fair amount of information to make a smart decision about your privacy. And then we have explicit consent, which basically just means that this affirmative action has to be in some way more grabbable for the individual. So instead of ticking a box, you, for example, have to sign something. It's meant to ensure that the person knows that now they're giving away consent for something important. So oftentimes it's done via signatures, signing a form, but concept is the same. Then again, you have the fulfillment of duties in employment relationships, especially when it comes to healthcare information that might have to be reported. Another interesting exception is the manifestly made public information. Can anybody guess what that means?
Visuals. So, visuals.
What would they do on a TV show?
Social. Instagram.
You're actually both on the really right track. So what it means is that if I manifestly made public something about my sexual orientation, my ethnic background, or my health, basically somebody else may be allowed to use this information. That is one of the wonderful reasons why you should always be careful what you put on social media. So if you put information about your sexual orientation, for example, obviously, it's not that this data is completely without safeguards, but if you make something manifestly made public, this can fall under this exception. Yes.
Make that as sound, set information, then you delete it. Does that like take away the right to use them?
That's a very good question. So, A, what do you delete is never really deleted. It's going to be somewhere else already. So maybe it helps if I explain to you where this concept was challenged the first time. So there is a very famous data protection lawyer. His name is Max Schrems, and he has a big NGO that is taking care of data protection enforcement. And he went, I believe, on a podium discussion in which he said that he was gay. And then Facebook tried to use this information in order to personalize his advertisement. So suddenly, after this podium discussion that was completely detached from Facebook, suddenly Facebook started giving him advertisement for all kinds of events that were applicable to his political opinion, to his sexual orientation. So he went to court. And he said, hey, the fact that I made this public on the podium discussion does not mean that Facebook can use that for advertisement. That's a different purpose. And he was given right. So the court decided in favor of him, saying, yes, it's true. Facebook cannot just scrape the internet, see that you have said something somewhere, and use that for advertisement. So there is a limit to this. But in either way, to be honest, I'm not quite sure how I can answer this. If you delete it, I think you can make a good point for you have tried to retract. But technically, in the real world, I think just try what you look what you post beforehand and try to avoid these situations. Because it's not only about what is legal. Obviously, I'm talking about what is legal, but it's also what is technically possible and what will people do with it. And that might be a different story. But if you're super interested in the question, send me a message and I'm going to try to answer it properly. Okay. Oh yeah, so we work with explicit consent. Again, there is information that has to be given to the person. That is all information that is relevant regarding the processing. The consent always has to be free. It cannot be coerced. It has to be specific. So again, this idea of saying, I'm okay with giving you any kind of data that you need is not enough. It has to be based on very specific information about what is collected. And yeah, pre-tick the boxes do not fulfill this requirement. It has to be an affirmative action. And explicit refers to the manner in which you're actually giving the consent. Okay, now to individual automated decision-making. As I said, this is Article 22. This is the only directly applicable version in the GDPR that targets automated decision-making, so machine learning data. The definition of individual automated decision-making is that you need to have a decision that is based solely on automated processing, including profiling, that has similarly or legal or similarly significant effects. Decision is basically anything. It's a very wide definition. So you can use the word decision as you would use it in the normal context. Basically, it's if an opinion or an attitude towards a person changes, and that might be acted upon. That is what you can imagine. So in a normal way, most prominent example would be credit scoring. I assess a little bit about you. Based on that, I take a stance toward you, and I will act upon that by giving you a loan or not. Solely automated processing refers, yes. Solely automated processing refers to processing where you don't have human involvement. And this human involvement, in order to not apply here, has to be meaningful. And that means you're not just putting a token human there that ticks a box, and then you're out of Article 22. It means that solely automated processing is used when there's no human that has the decision-making power. And that also means that if you do not want to fall under Article 22, you need to have an involvement of a human that makes the AI tool that you're using an aiding tool. So the person, in order to be involved properly, would need to have the possibility to make a decision. Possibility and need to. So as an example, again, credit scoring. If I use an AI tool to give me a basic understanding of information, make me some nice charts about income, outcome, and so forth, that is not solely automated processing. But if the credit score spits out a yes or no for a loan, that would be automated processing, especially if then nobody checks it. Now we have legal effects or similarly significant effects. That means legal effect means my legal rights are changed. So, for example, if I would apply for social security services, housing benefits, depending on whether they're depending whether this is accepted or not, it changes my legal right? So if I'm accepted for social benefits, it changes my legal right. If I'm denied social benefits, that also changes my legal right. That would be a legal effect. Now we say similarly significant effects are basically effects that have a long-lasting impact on the person and that change their opportunities, their choices. So they have to be quite big in order to be considered. Yes. As we have talked about Facebook already, online advertisement is an interesting case. So I haven't given you the definition of profiling so far. I think that would be sensible here. Profiling basically means that you assess certain characteristics about a person in an automated manner. So online advertising can fall via also profiling under Article 22. It's not a super clear-cut case, but it depends on the intrusiveness of the profiling, how much you track individuals across sites or different devices, on the expectations of the individuals. So do they know, are they expecting that you're going to profile them? The way the advertisement is delivered. So is it somehow everywhere after the profiling? Is it delivered in a way that it kind of nudges me to a behavior that might not be good for me? And obviously, whenever the advertisement is using vulnerabilities they know that they can find about you in order to nudge you into a certain behavior, it can fall under Article 22. So then the question is, what does it actually mean? So if you fall under Article 22, there's additional safeguards that you have to apply, and there comes an additional right for the person that is subjected to it. So let's assume you have automated decision making, it produces legal effects, it's solely automated, there is a decision made. What happens is that the person you make a decision about has a right to ask for explanation about the decision making. The underlying idea is that the person should have a right to actually go to court to complain, to say, hey, this decision making was faulty. And in order to protect that, you need to help the data subject, the person whose data is processed, understand how was a specific decision reached. If you have a human that makes a decision, they will be able to justify, I made the decision based on ADC. If you have a black box model, that might look different. So let's first talk a little bit about how these explanations should look like. They should not be the source code. Nobody's asking that. But what they should be is targeted to a specific individual, meaning there is a difference if you're trying to give an explanation to an ML engineer or to a senior or to a child. All of them have the right, and you need to be able to explain how a certain decision was made to all of them in a way that it's understandable to this person. One case that has come up is a very interesting case of credit scoring again. So credit scoring seems to be the main reason why we look at Article 22 at the moment. And basically what happened was that there was a person that wanted to make a mobile contract that was worth 10 euros per month. And she was refused that contract based on insufficient credit The credit score was made by a company called Dun& Bradstreet, and she rejected the accuracy of the decision making and she wanted an explanation. This went through different instances, and somewhere in the middle, an Austrian court found that Dun& Bradstreet had not fulfilled their requirement of providing an explanation that was understandable, basically providing an explanation at all. The case was then referred to the CJEU, which is like the European court. And the Austrian court asked some questions to the European court and said, hey, does this right to explanation actually exist? Because it's not in the rights that we have seen before between Article 12 and 21. It is a combination of Article 22 and information rights. So the first question was, does it actually exist? There's been a lot of discussion in literature for years. We need to know, do we have to apply it? And if so, how does it look like? And the CJEU said, okay, it does exist. Controllers must provide the actual procedure and the logic involved that were applied when making the decision. They also refer to counterfactual explanations, which is basically if you're trying to explain how were you denied the credit score, one way of saying of providing the logic would be to say you would not have been denied the credit score had you earned 50 euros more a month. That was one of the ideas of how to provide an explanation that is really intelligible and easily understandable for somebody that doesn't have a technical background. They also said just disclosing the algorithm is not going to help anybody understand how the decision is made, so this is not required. And one more point they brought up, or they decided upon, was trade secrets, because basically Dun & Bradstreet had said that they do not need to disclose anything because their tool is covered by trade secrets. The court here found a super great solution. They said, okay, if you say it's trade secrets, then show me the trade secret and we decide what you then have to disclose and whether it's really a trade secret. So that was fantastic. It also means that nobody can get out of this out of Article 22 by saying, sorry, trade secret, we can't disclose. So in the end, the judgment confirmed, yes, there is a right to explanation. Yes, it has to attach to the data subject. So it has to be an explanation after the fact. The decision has been made, and now we have to explain how this decision has been reached. To any person, depending on their background, this explanation has to change. It has to be intelligible. And very important for the future, it's about the logic that was actually involved in the processing. This is extremely important when we look at the methods that we have for explainability. This is an example from the ICO, that is the UK Data Protection Authority. Every state and every member state in the EU has a data protection authority that issues guidelines, takes on cases. This is from the UK, and basically it's just an excerpt. They have many different methods that apply here, but when you consider how you want to explain to a certain data subject how you reach the decision based on automated decision making only, you need to think about, firstly, what is the background of this person? How can I explain? And then you have a lot of methods, and some of them might be more applicable than others. So the CJEU said counterfactual explanations, they might be great because they're very intuitive. On the other hand, it might not always be very realistic that you can create those for every single scenario. Very prominent are Sharp and Lime. So basically, they use surrogate models in order to approximate the initial decision. And I hope you already hear they approximate. So it's not really the case that we can always expect them to pick up on exactly what was the decision-making factor. It's an approximation only. It doesn't give the actual logic necessarily. So be careful with this one. But for that, it's oftentimes used. Then we have feature importance globally. It's not an individual reasoning. So I wouldn't use it under Article 22 for the simple reason that we have to explain a specific decision. However, there's a lot of guidance. There are a lot of different methods. And the end of it is choose wisely in accordance with the context and think about these things before you implement. The easiest way to avoid getting into mess because of explainability methods is always to have human involvement by design. That means if you know you have very sensitive information, you have special categories, and you make automated decisions, do you really need to have them 100% automated? If you cannot explain them, think about human involvement from the start. Try to make the system as trustworthy as possible, and you're not going to deal with this later. Yes, so as a very short recap, okay, that might look a little bit stupid, I'm sorry. What we've gone through so far, and I'm sorry if I'm boring you, first, the principles of processing always apply under the GDPR, don't forget that. We have bases for data collection, lawful bases. We have two different types of data, normal personal data, special categories of data. We looked at solely automated decision-making and profiling. Next thing after that you look at is explainability, and in the very end, you should think about deletion. So are there any questions until now? Nothing so far, wonderful. So what is the connection to federated learning? After all, it's a federated learning course. Due to the fact that the legislation is not picking up on different methods, this is super general and vague, what I'm telling here. For federated learning, automated decision-making and their explanation is not actually solved. It's a question of research. Generally, you can always say the more transparent your models are, the easier explanation becomes. So pay attention on explainability and transparency from the very start of your design. And again, if you cannot explain and you have very sensitive use cases, think about human involvement. Okay, main takeaways so far we already had, so I'm going to jump this. And the next thing we're going to look at is the AI Act. This is going to be much shorter, so don't worry. The AI Act does not attach to personal data, it attaches to AI systems. And an AI system is basically any AI system that has some kind of autonomy. It lays down additional requirements for high risk. It prohibited some AI systems. And importantly, it can apply at the same time as the GDPR. So if you have an AI system that uses personal data, they can apply simultaneously. So as I said, the AI Act, just going to try to make it a little bit bigger. The AI Act thinks in risk categories. We have minimal risk that is not really dealt with in the AI Act. Limited risk, high risk, and unacceptable risk. Unacceptable risk are things like credit scoring. They are simply prohibited. Not credit scoring, social scoring. And high risk are acceptable, but they need to fulfill some additional requirements. Okay, now I messed this up. Okay, so what is a high-risk system? A high-risk system can be defined in two different ways. The first one is dependent on the use case, and those use cases are listed in the AI Act. So whenever you deal with critical infrastructure, education, employment, essential services, law enforcement, migration, asylum, or administration of justice, you automatically fall into the high-risk use cases. Or then you define an AI system based on the system characteristics themselves. So if you significantly affect the rights or the safety of individuals, if you lack transparency or human oversight, and if you're using your AI system for profiling or automated decision with legal or significant effects, we've seen that from the GDPR, then you fall under high-risk AI. The AI Act also has the right to explanation as a duty to explainability when it comes to high-risk AI systems only. And it's basically very much the same as the GDPR in the sense that it requires clear and meaningful explanations of the role of the AI system in the decision-making process itself and the main elements of the decision taking. The AI Act is very new in the sense that some of the requirements of the AI Act are only going to come into force this year and next year. So it's not been tested very well, but it looks pretty similar to the GDPR. And you're going to fall under both. So in order, if you have high-risk AI systems, you have additional requirements that might be important for you. One of them is risk management. So as I said, the AI Act attaches to the risk. And risk basically means the potentially negative outcomes and how probable they are. So in order to be compliant with the AI Act, you want to have a risk management plan in which you lay out potential risks, their mitigation, you document it, you document how you're trying to mitigate a specific risk, you have data and data governance, or you have training, validation, and testing data that is subject to a whole management process from the collection to deletion. Importantly here, I've introduced in the GDPR, we have a general prohibition on processing special categories of data. There is an exception in the AI Act, and that is when it is meant when there's no other way to detect bias. So in order to test for bias, you can use special categories exceptionally. And otherwise, you need technical documentation. You need to, basically, as you're going to do in your federated learning, how are they called, projects? Usually you're supposed to say, I collected the data from here, I chose the model based on this, these were my design choices. That is basically what you have to do in the real world when you fall under high-risk AI. So just to go through this one more time, we have a credit scoring system. We wish to implement it. So person A, we want to decide if person A and any other person gets a loan or not. Which data should we collect? Income. I'm sorry?
Loans, like how much he has in money.
Yes. Okay. Anything else?
The spending, how much you spend relative to your income.
Yes. Wonderful.
Gambling.
Very good point. Yes, this is a mean question because basically you're allowed to collect any data that is absolutely necessary for the purpose of the loan. Which law applies? We've seen two. Which one applies?
Well,
Perfect. Both. Both because we have personal data and we have an AI system. Is this an automated decision? I've unfortunately already taken it away now. Yes, it is, unless there is a human making the actual decision. There's a question. Oh, that's so nice. Thank you. Okay. So, as a final step about AI Act and GDPR, just very, very simply, difference in scope, GDPR attaches to the processing of personal data, AI Act attaches to AI systems. The whole purpose of the GDPR is to protect personal data and ensure the free flow within the internal market. The AI Act tries to ensure that that AI systems are trustworthy, you have risk management on them, you're not going to damage anybody, you're not going to risk the safety of anybody. Again, GDPR has no real risk attachment. AI Act has, and the GDPR mostly gives rights to data subjects. And again, please remember that those are rights that you have to enforce. If you ever wish to use your rights against a specific service provider or tool, look into the privacy policy. They are required to mention an email address and the contact of the person that is responsible to responding to you, usually within 30 days max. yeah, the GDPR also lays down principles of processing. And then the AI Act basically requires a lot of risk management, documentation, ensuring that you have taken all possible routes to make smart decisions. You have made your design choices based on a good understanding on how to mitigate risk. We're going to jump into the next topic now. So are there any questions about this part? Okay, I also don't see any in the chat. Okay, then we can move on. What I want you to remember from this section, again, the AI Act and the GDPR can apply simultaneously. That is the most important part for you, I believe. So, as a last topic, and this one is now detached from the GDPR and the AI Act, it was important to us to also introduce very shortly what are the actual contemporary problems in privacy. And social media platforms have been the absolute stars in privacy problems for years, and probably they will be in the future. There are several concerns about social media platforms. There are several court cases about social media platforms. One, because they collect an enormous amount of personal data, and they might not always use this data in your favor. So if we have recommender systems that are extremely strong, do they manipulate you to a certain behavior? Are they addictive? Do they manipulate you to buy certain things that you didn't need, that you didn't want, to make choices that are not good for you? That is one. Then platform power also means constant surveillance against across different websites. Your behavior is constantly tracked and sold. Another point is that platforms are not making it easy, even for those who know that they don't want their personal data to be processed in a specific way, to actually know how it's processed. Have you ever looked into the privacy policy of Google, for example? Okay. I've been doing this for years. I don't understand it. It's insanely long, and privacy policies are meant to inform about the processing that is happening about you. But they're insanely difficult, long, ununderstandable. There's no real rules on who you have to contact for what. And that is very typical for these very big platforms. It's very hard to make to get your rights. There's also a lot of evidence on social media being damaging to the mental health of teenagers, adolescents. And that's why, for example, Australia prohibited the use of some social media platforms for children. Also, what is, especially now, when many social media platforms are from the US, under the current political system, very interesting, is that social media platforms have a tendency to help very well with spreading misinformation and hate speech. And obviously, this is very worrying for everybody involved. Beautiful about social media platforms is that it's very easy to showcase every single law that we have discussed. The GDPR applies, and there are GDPR cases for the processing of personal data, the fairness of the processing of personal data. The AI Act applies where you have recommender systems, and you have the Digital Services Act for content moderation. I don't know if anybody has seen that, but there are a lot of discussions about content moderation on X and on Meta. And content moderation is extremely important in the sense that it protects you from hate speech. It protects you from seeing illegal content, already not only seeing it, but also those who are depicted in it. So for that, we have the Digital Services Act in the EU. We have the Digital Markets Act that targets specifically those very, very big online platforms. And it's trying to curb the market power that these tools have. This is an example from only GDPR fines against Meta. Now they accumulated to approximately a little bit more than 2.8 billion euros. First one was for EU-US data transfers. This is a little bit out of the scope of here, but whenever you transfer information outside of the EU, you need to make sure that the destination country has the same amount of safeguards for the data. So it doesn't make sense that I protect the data and then I ship it off to somebody who's just like distributing it in the world. So for this, there was something called Privacy Shield in between. There's the idea that you can make contracts with additional safeguards. Meta violated that. Then we had children's privacy concerns, behavioral ads, data scraping breaches, transparency breaches, passwords were saved in plain text somewhere. There's just everything that can go wrong. Right now, the two most recent cases were about Meta and TikTok, and those were investigations under the Digital Services Act. So here we're talking about content moderation and the system design itself. And what was found was that both had breached the DSA. TikTok due to overall addictive design, highly personalized recommender systems, infinite scroll, push notifications, autoplay, and basically a potential fine for all this can amount to 6% of the worldwide turnover of the company. Both companies were also found to have breached the idea of notice and action. So this is about the actual content control. If you see that there's illegal content, there's very disturbing content, and you want to report this, you have the right to do so, and the platform should make it easy. But what the platforms did was they were making it extremely hard for people to actually try to say, hey, here's illegal content, and I mean, these can be cases of child pornography, like really disturbing stuff. And they didn't really allow users to do that. They made it super hard, which is against the DSA, fortunately. Also, they didn't allow users to actually challenge content moderation decisions. And this one is also a big one in the sense that if you cannot challenge content moderation, when does it amount to prohibiting me from free speech if somebody doesn't like what I say and there is a content moderation mistake or it's done on purpose? Where is the line? That's why you're supposed to always have a recourse for content moderation in case the decision was mistaken. So overall, I'm done really early. So you've seen that we have the GDPR applies to personal data processing. And that is a right that is a legislation that is important for you as the people whose data is processed, but also as future machine learning engineers or whatever you're going to become. The same is true for the AI Act. Remember that it's risk-based, and remember to check also for the use cases. And yeah, maybe as a little takeaway, there are a lot of problems with the protection of privacy, and there are a lot of companies that challenge privacy. So whenever you think that your rights might be violated or you have additional questions, make sure to raise those questions, because also that helps the overall development of privacy protection and in the end society and the enforcement of the GDPR. Now it's time for questions if you wish to. Otherwise, I'm going to let you off super easy and fast. Oh, the assignment. Oh, yes. Very good question. Thank you. So you will have an assignment this week, but it's going to be super easy. It's only questions. Obviously, I haven't taught you anything technical. All the questions that are raised should be answerable with what I've said and the slides. So just go through the slides thoroughly and you're going to find all the answers for that. It shouldn't take too long.
Question, you have a slide about all the points down there.
Yes.
They all know like, is there any like system to pay out victims to, or do all the fines just go to?
That's a very good question. Firstly, those are fines that were imposed on it, but they were not paid yet. So that is an important part. The way that this functions is that you first have these findings, but Meta can still challenge this in court, and they are not done yet. So these fines haven't been paid. And to be fair, the way how these fines are going to be used is not entirely transparent in a sense that I couldn't tell you if there's anything going back to the victims, because there are cases in court where you would allege privacy violations. then you would claim damages. But these are, I believe, independent investigations, but I'm not 100% sure. Best way to figure out is go to NYOB. That is the NGO that is responsible for almost all of these cases, and they will publish where the amount of the money goes and if it's paid. Yes, please.
Two questions. First one is like about the fine again. Is it like a one and done thing? You, as in they pay the fine and then it's done, or is it actually required or enforced so they have to change their system and for some time?
Very good question. The way that this is usually done is that first the investigation is made. The company is confronted with the results and they have a time span in which they're allowed to fix it. And then if it was like a super big violation, so the violations are basically dependent on which rights you violate, you have a certain range of fines usually. The maximum under the GDPR is 4% of the worldwide turnover. And then when the company had the possibility to arrange, there is a decision on a fine, but that does not relieve them ever from actually correcting the mistake. So it is possible to get fines several times for the same thing.
And I had one about the AI Act. Is it only used to make imports for the personal data? Also, like, can you also make fully automated decision using AI, but not on personal data, but on also things that are important but not those?
Yes. So there are two interesting points that you actually brought up that I didn't talk about, which is great that you brought them up. The first one is you can still make decisions, not about persons, without personal data. You will still fall under the AI Act, and the risk categories will depend most probably about on the use cases then. So if it's, for example, critical infrastructure, you'll still be under the AI Act, you'll still be a high-risk AI system. What I haven't mentioned before, and this is not a very clear concept, but for Article 22 also, and also the same applies to the AI Act, it is not necessary that the initially collected data is personal data. So if you would end up with a system where you collect any kind of data that is not personal data, that via the output makes inferences about an identifiable person, you can still fall under these requirements. I hope that made a little bit of sense. You had a question?
So GDPR is very specific and also AI, right?
Yes.
So, and then we talked about the social media, which is like US based.
Yes.
So how these European laws are dealing with the system which are not EU based? We can find somebody who's not kind of based in Europe.
Yeah, fantastic question. That actually shows the brilliance of the GDPR. The GDPR applies not only if the company is situated in the EU, but only if you target EU citizens. So every company that targets EU citizens has to have a representative in the EU. So via this line, the fines are made. Which, by the way, also causes the fact that you have additional requirements for when you transfer data outside of the EU. It has this effect that it also forces or nudges other companies into being compliant with the GDPR or have similar standards so that data can be transferred. Did that answer your question? Yes.
Like, about the AI related data protection, like how would you rank the different countries who are more kind of advanced in the AI regulation compared to Europe, for example? What is the like a big difference between US and Europe and other countries?
That's actually a cool question. So the EU GDPR is seen as a standard worldwide. So after the GDPR came into force in 2018, there was like this global push towards regulation. Because as I said, there is this external effect that goes through different territories. When it comes to other countries, there are a lot of countries that you will find that now have similar regulations to the GDPR. AI Act is something special. When we're talking about the US, the system is completely different. There is no fundamental right or human right to privacy. The system is completely different in the logic. And personally, I prefer the EU. I think having a fundamental rights standard that is implemented is much better. If you ask a company, they will probably not go for the EU based on the amount of work it takes for documentation, responsibilities. But at least there is a lot of legal security here. So my number one is the EU. Okay, let's check out the. Oh, does number 5 have an assignment or just quiz questions?
With my,
Yes.
I think it has the quiz questions and it has the coding. So.
Okay, and I believe that the same is true for lecture 4. So in order to answer the question whether there are quizzes and assignments, yes, there are quizzes and assignments for, I believe, every lecture except of this one. This one has only questions in the form of a quiz, so you just need to tick boxes. Okay, I don't see any more questions. So, oh well, no, I still took a lot of time from you. If you don't have any more questions, I'm going to let you go then. Thank you very much for coming. Oh, yes. I think you can unmute yourself if you wish to. Yes, yeah.
Hello.
Hi.
I just follow the course out from outside the Alto,
Mhm.
and usually I get those quizzes from an email from Young, Alex Young.
Yes.
But just for the 4 and the 5th one, I did not receive any, so that's why I asked the question, because I didn't know whether they were there any quizzes or not. And I actually like to answer them because they give me a deeper understanding of the course. So that's why I'm asking.
Oh, okay. Would you mind sending a message to Alexander Jung directly to ask for them? Otherwise, you could also send me. Sorry.
I could do that, but I'm just like I'm not sure whether the Alto server would allow an outsider email to send emails to like any personnel of Alto. So maybe you could help me with this one.
Okay. I put my. I'm not in this meeting. Okay. So I put here my personal email address. I will talk to Alexander and I will ask if he or the TAs know what is the problem. And if the problem persists, please drop me an email so that I know and I can try to fix this for you.
Okay.
Okay. I hope that helps, but I will ask and I'm sure we can fix it. Are there any other questions at the moment? No? Okay, then. Oh, yes. I'm sorry. Oh, okay. Well, if not, then thank you very much for listening. And again, if you have any questions, also those online, my email address is diana.pfau, like my name, @alto.fi. So if there's anything more you want to ask, please don't hesitate to send me an email. Thank you very much and have a nice day.